Okay, welcome everyone to the second session of the day. I'm Danny Waltz, a managing attorney on the litigation team here at Animal Legal Defense Fund. I'm located in Washington, D.C. area. And while I would love to be seeing everyone here in person, one advantage of a virtual symposium is that we get the expertise of top animal lawyers from across the country. This panel is a perfect example of that. I'm thrilled that today we can deliver Delcy, Mary, and Zeynep's perspectives and comments on legal standing straight to your house, office, school, or wherever you're watching this panel. A few housekeeping comments before we get started. All sessions feature closed caption subtitles. To enable this feature, click the upward arrow near the CC button on the bottom of your screen and select Show Subtitles. Please enter any questions you have into the Q&A box that you'll see at the bottom of your screen. We'll try to get to as many questions as we can. The symposium is being recorded, and the recording will be shared with you later via email. Please take a moment to answer the poll question on your screen. If you are seeking continuing legal education credits for this session, please click yes. Attorneys seeking credit will receive information via email after the symposium concludes. Okay, great. Thank you. Now, on to the panel. I'd like to introduce our impressive team of panelists in the order that they are speaking. First is Delciana Winders. Delcy is an associate professor of law and the director of the Animal Law and Policy Institute at Vermont Law and Graduate School. In addition to teaching, she has practiced and practices animal law in a variety of settings. Second is Mary Hollingsworth. Mary is a visiting assistant clinical professor of law and the director of the Animal Law and Policy Clinic at Harvard Law School. Before coming to Harvard, she was an attorney in the Environment and Natural Resources Division at the U.S. Department of Justice. And finally, we have Zeynep Graves. Zeynep is a senior attorney at the Center for Biological Diversity. Before going to the center, Zeynep was the associate director of litigation for the PETA Foundation. You can learn much more about our panelists on our symposium webpage. We're going to first hear from Delcy to introduce the concept of legal standing. Take it away, Delcy.
Thank you. Thanks so much, everybody. So yes, I'm going to give you a brief overview, perhaps review for some of you, but I want to make sure we all have at least some shared foundation. So I'm going to talk about what standing is, particularly in the federal US context, what it entails or requires, and also a little bit about where it comes from, including some history that I think is helpful context. So it's rooted in our Constitution. So Article 3 of the US Constitution, which sets forth the scope of the federal judiciary's authority, provides that the scope of that authority extends to all, quote, cases and, quote, controversies. So if something is not a case or is not a controversy, then the federal judiciary lacks jurisdiction over it. And so the Constitution doesn't define a case or controversy, but the current test for that, as established by the US Supreme Court, is that it's a case or controversy if the person bringing suit first suffers an injury in fact that is concrete, particularized, and actual or imminent. And second, that injury in fact is caused by the challenged action or inaction. And third, that a favorable judicial decision will likely redress that injury. So the three requirements are injury, causation, and redressability. And the Supreme Court has described those as the, quote, irreducible constitutional minimum of standing. So these are the prongs that we'll be focusing on today. I suspect we'll primarily be focusing on the first one, injury in fact. And in fact, the Supreme Court has described injury in fact as the first and foremost element of standing. But putting my teacher hat on for a minute, I really want to urge you not to overlook the other two, causation and redressability, because you need to have all three for a federal court to have jurisdiction. And this is something that the court can raise on its own at any time, and really it's seen as having a duty to assure itself that it has jurisdiction. And so you always want to be prepared to address all three prongs. So we're going to focus on what the law of standing is today, which is that test that I just described, and where it's going, because we're pragmatists and practitioners. But I think some historical context is helpful, especially for us to maybe envision what the law of standing might become. Or maybe I've just been in academia for a little bit too long, but humor me at least. So this was not always the test for standing in the US. It's actually a fairly recent invention. The Supreme Court first discussed legal standing in terms of an injury in fact in 1970. So yes, that was a while ago, especially for those of you who are younger. It was 55 years ago. But that was more than 180 years after the Constitution was ratified. So the injury in fact test has only been part of our standing jurisprudence for less than a quarter of our country's history. In addition to that, as Cass Sunstein very helpfully outlines in an article, Injury in Fact Transformed, that I recommend, the Supreme Court basically made it up. He explains, quote, "The concept of injury in fact did not come from Alexander Hamilton, John Jay, or James Madison. It does not appear in the debates in the founding era." So in short, the test we're talking about hasn't always been the test, and it doesn't always need to be the test. But it is the test today that you need an injury in fact that is both concrete and particularized. And so because of that, courts will, at least sometimes, deny standing if you don't articulate an adequate injury, or if your injury is hard to distinguish from those of the public, members of the public more broadly. So in 2021, the Supreme Court decided a decision called TransUnion versus Ramirez, in which it doubled down on, and I would say greatly expanded on, the concreteness requirement in the injury in fact prong. So the court in TransUnion said, quote, "Central to assessing concreteness is whether the asserted harm has a close relationship to a harm traditionally recognized as providing a basis for a lawsuit in American courts, such as physical harm, monetary harm, or various intangible harms." So Sunstein calls this a radical ruling in which the Supreme Court concocts a new approach, making brisk gestures in the direction of originalism while failing to actually ground its decision in originalism, probably because doing so was not possible. But whether or not it's well grounded in the Constitution, it is the law of the land. And a lot of what we're going to be talking about today is rooted in this pretty recent Supreme Court decision that raises a lot of issues and raises a lot of questions. So for all of these reasons, now more than ever, in animal advocacy cases, it is not unusual to have to litigate about standing for years before there's even a possibility of the court getting to the actual substantive merits of your claims. So standing is a little bit important. Thanks.
Thank you. Thank you very much. Oh, very much, Delcy. I actually have one quick question for you, which is, do you see standing, just the issue of standing to be, is it one that appears more in animal law type cases than in other areas of law, or are we just seeing a sort of a sea change in standing across all areas of law?
I think I haven't done a quantitative analysis. I think we probably do see it a bit more in animal cases and environmental cases, but I think more broadly we see it in public interest cases where the focus isn't on economic injuries, and those are the kinds that the courts are willing to recognize very easily.
Okay, thanks. We'll hear more from Delcy in a bit, but next I'd like to hear from Mary, who is going to focus on a theory of standing called aesthetic injury.
Thanks, Danny. As Delcy explained, one of the required elements of standing is the injury in fact, or an invasion of a legally protected interest. In animal law cases, one of the primary types of injuries asserted is the aesthetic injury, which has been recognized by courts since the early 1970s. In Sierra Club v. Morton, the plaintiff complained that the challenged action, which involved destroying part of Sequoia National Forest to build a ski resort, quote, would destroy or otherwise adversely affect the scenery, natural and historic objects, and wildlife of the park and impair the enjoyment of the park for future generations. On that point, the Supreme Court noted that such harm may amount to an injury in fact, as aesthetic and environmental well-being, like economic well-being, are important ingredients to quality of life. In other words, the court concluded that the desire to enjoy nature or observe a species in its natural habitat is a cognizable interest. 2 decades later, Justice Scalia, of all justices, in Lujan v. Defenders of Wildlife, explained that, quote, of course, the desire to use or observe an animal species, even for purely aesthetic purposes, is undeniably a cognizable interest for the purpose of standing. The validity of making a standing claim based on aesthetic injury was again reaffirmed by the Supreme Court in 2000 in Friends of the Earth v. Laidlaw Environmental Services. In that decision, the Supreme Court noted that the injury that needs to be established is to the plaintiff, not to the environment, or in the animal law context, not to the species or particular animal, but to the plaintiff. So this is an injury or an interest that has been recognized over the course of many years and a number of times by the courts. So who can establish an aesthetic injury? I like to think about aesthetic injury in animal law in terms of 2 contexts, the wildlife context and the captive animal context. In the wildlife or environmental context, you would be looking for plaintiffs or members in the associational standing context who use or frequent areas where you would expect to find the species at issue and are persons for whom the aesthetic and recreational values of the area will be lessened by the challenged activity. So in Laidlaw, the plaintiffs will bring a Clean Water Act claim against a company that was violating the mercury discharge limits of its permit. The standing declarants included organizational members who lived and previously recreated in the area. So their standing declarations read like, I live close by, I used to go, bird watching and picnicking and camping in this area. And, I've stopped doing so, or at least stopped sort of using the sort of coming in contact with the waterway because they were concerned about the levels of mercury in the water. In an Endangered Species Act context, for example, you may identify a researcher who has studied the species and enjoys viewing the species and its habitat, or someone who enjoys observing certain species in an area that the person frequently recreates. And either of those would establish aesthetic and recreational interests. By reducing or removing the species protections under the ESA, or by authorizing a project that may reduce the number of individuals of that species in that area, the person's aesthetic interests would be harmed. In the captive animal context, the interest has been described as an interest in viewing animals free from inhumane treatment. The declarant can be someone who works with a particular animal at risk, or someone who visits the particular facility and has developed a bond with particular animals. In 1998, the DC Circuit, in its decision in Animal Legal Defense Fund v. Glickman, expressly recognized a cognizable aesthetic interest in observing captive animals living under humane conditions. So in that case, the plaintiff was challenging a USDA regulation that required regulated facilities with non-human primates to develop and follow an appropriate plan for environmental enhancement. But the agency was deferring strongly to the facility's veterinarian to basically come up with the plan and ensure that the facility was following that plan. this had resulted in particular facilities keeping non-human primates in inhumane conditions. So the court concludes that one of the standing declarants had experienced an aesthetic injury after the declarant explained that he had spent years volunteering with animal welfare, wildlife rehab organizations, was very familiar with the needs of exotic animals. He had started visiting this facility and actually had visited 9 times in the course of like 13 months. So he had, in seeing these animals, in particular singly housed non-human primates who are very social creatures, he had developed this bond and was injured by what he was observing. And the court said, yes, that constitutes an injury, in fact, that can establish standing. I think with one of the key things to keep in mind is that the injury must be imminent and continuing. As Delcy explained, the plaintiff must show not only that they have been injured by the challenge action, but this injury has to be imminent and continuing. So in the aesthetic injury context, that's typically shown by establishing that your declarant has specific concrete plans to return to the location where they would expect to enjoy the environment or observe the species, or in the captive context, that they're going back to that roadside zoo or that facility where they're observing particular animals and being harmed by what they see. So, for instance, in Lujan, the Supreme Court clarified that establishing that the individual has previously observed the animals and would like to do so again at some point in the future is insufficient to establish an injury. So basically the court explained that just because you have the intention to go back at some point in the future without any concrete plans would not suffice to show an actual or imminent aesthetic injury. And I think, as was mentioned earlier by Danny, I've spent over a decade at the Department of Justice handling Endangered Species Act cases. And I think this is the issue that trips up plaintiffs most frequently. It's that, yes, they can show, maybe they've gone to a location a dozen times and they love that area, but if it's not clear that they are returning, that they plan to continue, that they will continue to be injured, then that's typically the circumstance in which they're going to get dinged on standing. And I would say that's the only times that I personally have seen standing discovery take place at the district court level has been in that context where, the government is calling into question whether or not there actually is an intent to return. But I think that and ensuring that you continue to have standing at every stage of litigation are the two kind of areas that I would zero in on, or if you were planning a lawsuit. I can stop there. See if there are questions.
I do have a few, Mary. Thank you so much for the overview. I have some questions for you, but if other folks on the panel are also interested in answering, feel free to do so after Mary. So we heard Delcy mention TransUnion, and I think we're going to hear about some other Supreme Court case law about standing generally or certain aspects of standing. And I'm wondering if sort of, in light of the trajectory of Supreme Court decisions on standing, how concerned are you that either the Supreme Court or lower courts reacting or anticipating or reading the Supreme Court's tea leaves are going to act to scale back aesthetic injury as a form of standing?
So Danny, I'm afraid my answer is going to come back to haunt me at some point.
Oh no.
Sort of like famous last words, but at this time, I'm not particularly concerned about aesthetic injury, and I'll sort of explain why. So, of course, of course, there are always going to be cases in which, under the particular facts and the particular, the sort of particular declarations that are presented. The courts that have found that a plaintiff who was trying to establish like an aesthetic injury did not meet those requirements, and I think it often happens when the party asserting injury maybe doesn't connect the dots in terms of establishing that they themselves are the ones injured, or there's an issue at the associational standing, like the broader requirements, sort of in that context. But at least as of now, there doesn't appear to be any, circuit court split on this level, like on the issue of recognizing aesthetic injury. There, even the Fifth and the 11th circuits, I would say I would be most focused on those two circuits, like kind of raising red flags about how an injury or how a theory is being viewed. And you don't see, like, thus far there haven't been any decisions calling into question aesthetic injury, at least in the animal and environment context. There certainly have been some decisions where either they haven't recognized an aesthetic injury in another context, or there was a concurring opinion in the Fifth Circuit by Judge James Ho saying that it makes sense that the court didn't recognize or didn't determine that a particular plaintiff had an aesthetic injury because that sort of theory has been limited or recognized only in the context of animals and the environment. Although Judge Ho also then went on to say that the concept of aesthetic injury makes no sense, and how are we recognizing aesthetic injury and not other types of injuries? And Justice Thomas in TransUnion also had a dissenting opinion where he said something similar. It's like, how can we, here we are recognizing aesthetic, injury as one that establishes injury in fact for standing, but we're not recognizing these other injuries. And I don't know, I guess you could interpret that as like, hey, we're signaling this, the Supreme Court's signaling that they may be open, like the issue of aesthetic injury is open for discussion. But I think you could also say, like, hey, come on, we should be recognizing other forms of injuries as well, and not just aesthetic. And again, it's in a dissenting opinion. So yeah, as of now, I guess my opinion is that there aren't, I haven't seen, at least at the circuit court level, cases that are concerning on this front if you're using this form of injury to establish standing in an animal or environmental case. But I would love to hear if somebody else disagrees with me.
Thanks for that, Mary. I don't disagree. I think, though, if there are problems in the future, they might kind of come into that second prong that Delcy provided that helpful overview, in the causation. So especially when organizations are trying to address government regulations that the courts might, and just, trying to prove up that chain of causation. I think that might be kind of an area where we might see some attacks on in the future. We've seen kind of this progression of it becoming more and more difficult for plaintiffs to kind of establish that causation. in response to government action or inaction. But I think that would be the only area where I think, yeah, it might be ripe for future destruction. But I agree, not in kind of that injury in fact, and just like the, the core of aesthetic injury itself.
Sorry if it looks like I'm freezing. I can hear everything, but my camera may be freezing. I have another question that might relate to one of the comments or one of the questions that we received, which is to ask for more specific examples of aesthetic injury. And you know, perhaps maybe Mary, you could touch on this in responding to a question I have, which is one aspect of aesthetic injury constantly trips me up, which is does someone need to, to first experience the aesthetic injury of viewing an animal who's in inhumane conditions? Do they need to have accidentally come upon the animal, or do they have to have sort of know? I mean, is it a problem if they know that the animal may be in inhumane conditions when they first show up?
I'll tackle the first question first, which is what are some examples? So in the captive context, I think it has, as I mentioned, it's been described as sort of the interest in viewing animals in humane conditions. So I would say whether, and I think this has come up in the Endangered Species Act context, has come up in the Animal Welfare Act context. I think what we're looking for are facilities that are either like in the Endangered Species Act context, maybe taking an animal, which in ESA lingo means essentially sort of, maybe failing to provide adequate veterinary care, failing to, it's hot outside and the animal has no access to water, adequate shade, housing, those kinds of scenarios that, if you love animals or you are going to a facility and time and again, you're seeing an animal who's injured, who hasn't gotten vet care, something along those lines, that would be, harm your interest in seeing animals in captivity who are humanely and well taken care of. In the wildlife context, I think it's a little bit different in the sense that, again, going back to my Endangered Species Act and environmental roots, if you, let's say there's a particular bird species and you love to go out and, bird watch and see those birds in a particular area, or you like to go out and look for them and you would expect them to be in a certain area. And then, the federal government either decides to reduce protections for those birds, which makes you think, hey, that means, they, if there isn't as much funding and there isn't as much protection, that means maybe the population will decrease, or they are proposing a project that will damage habitat or that will somehow negatively impact this species that you go to in this area that you love. And that could make it harder to find that species. It can make it, it can make it harder to enjoy this area that you love. I would say those are sort of really standard types of injuries. I would say, we worked on a manatee matter, and if the level of protections for the manatee are reduced, that might mean that they would be more likely to be to not have access to forage or access, or there might be boats. There might not be speed limits for boats in the area, so that means they might be struck more often. So when you see the manatee, either there'll be fewer of them because they won't have access to their habitat and their foraging area, or when you do see them, they're injured, they're harmed. So hopefully that helps. But I would say those are some of the sort of obvious injuries.
I'm going to hop in and just add specifically to the question I think you asked at the very end, Danny, about does it matter if the plaintiff goes to a facility knowing that they're likely to witness violations, or I don't know how you phrased it, but that's the gist. And that has come up in at least 2 Federal Court of Appeals cases, Hill v. Coggins in the 4th Circuit and Kill v. Sellner in the 8th Circuit. And Kill v. Sellner in particular explicitly head-on addresses that. There was a contention that because the plaintiffs went to this roadside zoo basically looking for violations, knowing they were going to see violations, the contention was their injury was self-inflicted and therefore not cognizable. And the court firmly rejected that and said that mischaracterizes the injury. And the injury is caused by the roadside zoo's failure to provide proper care to the animals.
And I would just add, I agree with Delcy on that point, that I think you still have to establish, you can't just like show up, take the picture, provide the evidence and see that an animal is being kept in inhumane conditions, right? You still have like the ongoing injury to your aesthetic interest, the imminence of it, like you still have to go and I think establish a genuine interest in the specific animal. So I think provided that that all like the other aspects of the injury in fact requirement are being met, the fact that you sort of knew what you expected to see the inhumane conditions doesn't in itself call into question the injury in fact.
Great. Well, thanks. I think we could keep going on aesthetic injury, but unfortunately we have other theories of standing to discuss, and maybe we'll have time to get back to more questions at the end. But for now, we're going to hear again from Delcy, who's going to discuss a different theory of standing, which we generally call informational injury type of standing.
Thanks. Yeah, so I am going to talk about informational injury or informational standing, which is basically the idea that by being deprived of information to which you're statutorily entitled, you suffer an injury that is cognizable for standing purposes. And the big question is that alone enough for an injury in fact? And so I'm first going to talk about 2 key Supreme Court cases establishing that informational injury is indeed cognizable for purposes of Article 3 standing. And I'm going to give a couple examples of how animal advocates have used this type of standing. And then I'm going to talk about some recent developments and talk a bit more about the TransUnion decision that I mentioned at the beginning. So I'm going to talk about those 2 Supreme Court cases at the outset, and they have nothing to do with animals. And the precedent that they have established is very helpful to animal advocates. And I just flag this because sometimes I see students who are focusing their research, or even early career attorneys, they're looking for animal cases. They're trying to figure out like, where's the case that involves animals that can help me? But legal reasoning is analogical. And so you've got to look beyond the animal context, and you've got to identify things that can then be used to advocate for animals. And that's the only way any of these helpful decisions that we're going to be talking about today came to be. So with that, the first case I'm going to talk about is a 1989 U.S. Supreme Court case, Public Citizen versus Department of Justice. So just briefly, some background. The American Bar Association's Standing Committee on the Federal Judiciary historically and traditionally plays a role where when there are potential nominees under consideration for federal court judgeships, before they're made public, the executive branch would submit their names and other information to this ABA committee, and the ABA committee would then confidentially investigate them and then give a report and recommendation to the Attorney General. George W. Bush did not do this. Trump is not doing this, but historically and traditionally, this is the practice, and it certainly was at the time of this case. And then the president would decide whether or not to nominate based on this information and then other information that the government itself had gathered. So enter the Federal Advisory Committee Act, or FACA, which, among other things, requires that committees, councils, groups, whatever you want to call them, entities that are advising the executive branch, have to make their minutes, their records, their reports available to the public. And the ABA committee had not done this. And so the Washington Legal Foundation brought suit against the Department of Justice. The argument in response, as is often the case, was Washington Legal Foundation did not have standing. They did not have a concrete specific injury. And the Supreme Court rejected that argument. They said there's never been a question about someone having standing in a FOIA context, and the injury here is analogous. Therefore, refusal to give the Legal Foundation access to information that FACA required to be made available was, quote, a sufficiently distinct injury to provide standing to sue. The court went on to add, our decisions interpreting the Freedom of Information Act have never suggested that those requesting information under it need show more than that they sought and were denied specific agency records. There's no reason for a different rule here. But remember that quote as we proceed today. Never been a suggestion that under FOIA you need anything more than you ask for information and you were denied it. So that's the first case. Fast forward 9 years, the next key informational injury or informational standing case is the Federal Election Commission versus Aikens. And that case involved the Federal Election Campaign Act, or FECA. And that act imposes extensive record keeping and disclosure requirements on political committees, which are defined to mean any committee, club, association, group of people that either receives more than $1,000 in contributions or makes more than $1,000 in expenditures in any given year for the purpose of influencing any election for federal office. And so the situation there was a group of voters who contended that the American Israel Public Affairs Committee, or AIPAC, was a political committee within the meaning of FECA and therefore needed to make information public and was failing to do so. And so voters brought suit saying they were entitled to this information, and the Federal Election Commission challenged their standing. They said Congress lacks the constitutional authority to create an injury. They can't just manufacture a case or controversy, and there isn't a real injury here. And the Supreme Court rejected that argument. They said the inability to obtain information, again, well, more specifically what they were looking for was lists of AIPAC members and then their campaign-related contributions and expenditures. The court said their inability to get that information was a genuine injury in fact, in other words, an informational injury. So the court explained, quote, the injury, in fact, that respondents have suffered consists of their inability to obtain information, that information that I just described, that on respondents' view of the law, the statute requires that AIPAC make public. There's no reason to doubt their claim that the information would help them and others to whom they would communicate it to evaluate candidates for public office, especially candidates who receive assistance from AIPAC, and to evaluate the role that AIPAC's financial assistance might play in a specific election. Respondents' injury consequently seems concrete and particular. And then citing Public Citizen, the court said, indeed, this court has previously held that a plaintiff suffers injury in fact when the plaintiff fails to obtain information which must be publicly disclosed pursuant to a statute. There was also an argument that even if there was an injury here, it was a generalized grievance. And so there's sort of, as a prudential matter, sometimes the courts won't consider injuries that are broadly applicable across the population. And here the court said, even if this harm is widely shared, as long as it's concrete, it is an injury in fact for standing purposes. And they said the informational injury at issue here, directly related to voting, the most basic of political rights, is sufficiently concrete and specific such that the fact that it is widely shared does not deprive Congress of constitutional power to authorize its vindication in the federal courts. So based on these two Supreme Court cases, animal advocates have successfully relied on informational injury in numerous cases. Of course, in lots and lots and lots of Freedom of Information Act cases, but also in other contexts where laws require information to be made available and that information is not being disclosed. So one example is a case from District Court in DC, Friends of Animals versus Salazar from 2008. And that case involved information that the Endangered Species Act required to be made available. So the Endangered Species Act, Section 10, the permitting provision, says that all information that the agency, either Fish and Wildlife Service or National Marine Fisheries Service, receives as part of an ESA permit application has to be made available to the public. And here, the U.S. Fish and Wildlife Service was allowing canned hunt facilities, facilities with captive wild animals where people can pay a lot of money to come on for a guaranteed kill to bring a trophy home. There's still dozens of these facilities in Texas that are using endangered animals. So at this time, there was a regulation that allowed that shooting and killing of 3 specific endangered antelope species without going through the permitting process. And so the animal advocates, Friends of Animals, argued they had standing to challenge this regulation because it was effectively denying them access to information in the permit application that they would otherwise have access to, because the canned hunt facilities would have to go through the permitting process and they would therefore have access to it. And the court agreed with that. So a few years later, in another case, I relied on this same argument when I brought suit on behalf of PETA to challenge the Fish and Wildlife Service's practice of secretly issuing dozens of Endangered Species Act permits, what are called captive bred wildlife permits, that authorize facilities to engage in otherwise prohibited activities with captive members of endangered species. So takes of them, buying, selling. And so the idea there was quite similar to the Salazar case. We were being denied permit application information. And so there, the government didn't even challenge standing. They actually quite swiftly settled. And after many, many, many years of secretly issuing many permits every year, they started making them available, which gave access to a lot of information, but also related to that, the opportunity to comment on those permit applications and in some instances, successfully get them denied. I will say, I think we've lost more informational injury arguments than we've won. So I'll give you one example of that. That's a district court case out of California that I was also involved in on behalf of PETA, also against the Fish and Wildlife Service, also challenging Endangered Species Act permits. So there, we were challenging the issuance of permits to Ringling Brothers to export and then re-import endangered elephants and tigers for use in the circus in Mexico. And for some of those animals, they hadn't disclosed permit applications at all. And for some of them, there was no information about how the permit would enhance the propagation and survival of the species, which is required for permit issuance. And there the court said that we had indeed adequately alleged injury in fact, and said, quote, it's well established that the failure to obtain statutorily guaranteed information may be a sufficient injury in fact to confer Article 2 standing, and that we established that Section 10 of the Endangered Species Act creates an informational right that satisfies the injury in fact requirement for standing. And we had allegations that we regularly provided information to the public on animal protection issues through various platforms, and that our ability to do that was hindered by Fish and Wildlife's failure to ensure we had access to this information. So the court said that is enough for injury in fact. but then went on to say that the injury did not fall within the zone of interests. And I didn't talk about the zone of interest requirement when I talked about standing at the beginning. Historically, it's been seen as a prudential test and not a constitutional test, but nevertheless a standing requirement. And the idea there is that the litigant's injury is the type of injury that Congress intended to address when it enacted the underlying statute, in this case, the Endangered Species Act. The Supreme Court about 10 years ago said that the zone of interest test is really about whether you have a cause of action, not so much about whether you have standing. But whatever you want to call it, whether you call it standing or cause of action, it is a limitation on our ability to bring suit based on informational injuries. That is still very much alive. And in the case involving the Ringling Brothers permits, the courts said the point of the Section 10 Endangered Species Act disclosure requirement was not for organizations to be able to get information to inform their members or inform their public. It was for them to be able to meaningfully participate in the permit requirement. So with regard to this zone of interest thing and the nature of the injury, as I mentioned, in 2021 in TransUnion, the Supreme Court expanded the concreteness aspect of the injury in fact requirement. And in doing so, it specifically talked about informational injury. I think it's important to note that it explicitly acknowledged and did not overturn its previous recognitions of informational injuries as if sufficient for standing in both Aikens and Public Citizen. But then it went on to say, there must be, quote, downstream consequences from failure to receive the required information in order to have injury in fact. So the last sentence of the TransUnion decision is, an asserted informational injury that causes no adverse effects does not satisfy Article 3 standing. And so I think that's in tension with that quote from Public Citizen that I asked you to tuck away, which says our decisions under FOIA have never suggested that people requesting information need to do anything more than show that they sought the information and didn't get it. So now we've got a real tension between these two decisions. And so Kathy Meyer, in her piece, Standing to Protect and Advocate for Animals, that's part of the Brooks Institute Animal Law Fundamentals series that I highly recommend, described that last sentence in TransUnion as, quote, even ominous for FOIA standing. So the question is, where does that leave us with regard to informational injury? There is definitely, absolutely some uncertainty. And I don't have all the answers, but I'm hoping we can flesh it out a bit in the discussion with Danny's questions.
Thanks so much, Delcy. And I love how my camera freezes every time it's time to have a discussion. I think FOIA might be a good place to start with questions both for you and if other folks on the panel want to chime in as well. I loved how you talked about how, we need to look outside of animal law because, law is reasoning by analogy, and gave the example of how I think, what was it? Public Citizen did that with sort of reasoning out from FOIA. So, it seems to me that FOIA is really always going to be, or at least as of right now, untouchable informational injury. And some statutes are analogous, like FICA. But as I understand it, there are other statutes like NEPA, which would require the preparation of, in certain circumstances, an environmental impact statement that would need to be publicly disseminated, or the Administrative Procedure Act, which could, would, in certain circumstances, requires the sort of response to a request, petition for rulemaking that would need to be publicly disseminated. Those do not give rise to informational injury under some, or at least some courts have held that. How are courts sort of drawing these dividing lines about what's close enough to FOIA and what isn't. And are you persuaded by how they're doing that line drawing?
No, it's a mess. It's a total mess. And there we'll probably get into this, but there is a circuit split on when informational injury, when an inability to get information on its own is enough, and that might mean if it's ever enough. So one distinction the courts have drawn, and this is including in a Third Circuit case from last Friday. They've basically said it's one thing when you have a statute like FOIA, where the entire purpose, the entire reason for the statute is access to information. And then they try to distinguish that from other statutes. In that case, a statute related to voting rights, where there's a broader purpose and it has multiple mechanisms, and access to information is just one of those. I don't think that's a persuasive distinction at all, because I think if you look at FACA from Public Citizen and FICA from Aikens, those statutes had other components. They had broader purposes. They were not simply information providing statutes. So I think it's a bit incoherent at this point. I think we just need to figure out, it's also evolving quickly. And I'm happy to talk more about the circuit split if you want to get into that. But I think at this point, just as a strategic matter, we just have to be really mindful about where we're bringing these cases. And I think regardless of where we're bringing them, the prudent thing to do would be to lay out the injuries that you do suffer from downstream injuries from not getting the information, or for not the procedure not being followed, or whatever it may be. And I think in many cases that should not be too difficult to do, because you probably wouldn't be seeking this information or spending the resources to sue if there wasn't some additional injury beyond your mere curiosity not being sated.
Danny, can I, if I might add to this, I think in the examples that you mentioned, like a response to a petition for rulemaking or preparation of EIS or BIOP or anything like that, yes, the recipient or the, maybe a plaintiff, yes, they get information from those documents, but the purpose of the document is not the information itself, right? It's a action that the agency has to take that analyzes a particular situation and then provides a response. Whereas I think that's different than the FOIA context, which, as Dulcie just mentioned, like the whole purpose is to give information or give particular documents to the public. So I do think those are different, and I can see sort of the difference in treatment. So not treating a failure to act, like a failure to provide a response or a failure to prepare an EIS, as an informational injury. For what that's.
Just to jump on that and add to it, the Endangered Species Act cases that I mentioned, so those all relied specifically on Section 10C of the Endangered Species Act that says you have to make the permit applications available. In the antelope case, there was also an argument under Section 10D, which requires the agency to affirmatively make certain findings and publish them before issuing a permit. And the court rejected that and said, that's not an informational injury. And I think those fall more on the side of the examples that Mary was elaborating on.
Great, thanks. Actually, if I could just ask one more question, and then I think we'll need to jump to the next theory of standing. But I'm curious, Dulcie, how useful you think the informational injury is for animal advocates going forward. I mean, you've provided some helpful examples of animal cases, but I'm curious if you think that this will help open up litigation opportunities sort of across animal law, or are we going to be limited to a few statutory schemes?
I think we're limited, but I don't think that means it's unimportant. So there aren't a whole lot of statutes like FOIA that are focused on provision of information. And these cases aren't going to really get us at the substantive legal issues. And they didn't in the examples that I gave. Nevertheless, I think they're critically important. There's so many reasons that access to this information is important for animal advocates, perhaps now more than ever. I mean, one is just to be able to monitor whether the government is doing what it's supposed to be doing vis-a-vis animal protection, what Congress tasked it with doing, so that then if it's not, you can seek redress, whether it's through the courts, through the political process, through the courts of public opinion, but then also so that you can get help to those animals who the government is failing to help, so that you can pursue other mechanisms, maybe under state or local law, or under the Endangered Species Act if they're failing under the Animal Welfare Act. So it's really, really important, but it's not going to get us across the finish line in terms of establishing animal rights by any means.
Oh, thanks so much, Delcy. Uh, Finally, we'll hear from Zeynep, who is going to talk about our last theory of standing for the day, which is standing for an organization to be a plaintiff in a case based on organizational injury.
Great, thank you, Danny. So what do we mean by organizational standing, often called haven standing? So like Danny mentioned, organizational standing allows an entity like my organization, Center for Biological Diversity, or Animal Legal Defense Fund, to bring suit on its own behalf when it seeks redress for an injury suffered by the organization itself. So this is distinct from associational or representational standing, where an organization sues to redress injuries suffered by its members. And the Supreme Court has its own test for associational standing, we won't go into, but when suing on its own behalf, an organization must independently meet the same Article 3 requirements as any individual plaintiff, so injury in fact, causation, and redressability. So I'll start with beginning with the foundational case for organizational standing, which is Havens Realty Corp v. Coleman. This is a 1982 case that sure most of you are familiar with, but just a little refresher because this is really where it all started. So the Havens case involved allegations that Havens Realty Corp, a company that owned 2 apartment buildings, engaged in racial steering, essentially providing false information about apartment availability to one of the organization's testers, Coleman. He was a Black tester, while offering accurate information about housing availability to Willis, a white tester. Organizational plaintiff Housing Opportunities Made Equal, or HOME, was a nonprofit dedicated to promoting equal housing opportunities in the Richmond metro area. Its core work included providing housing counseling services and investigating and referring housing discrimination complaints. So HOME sued on behalf of its members. There were individual plaintiffs at issue, and HOME also sued on its own behalf, but it abandoned its associational standing claims once it got to the Supreme Court. So the key question before the court with regards to organizational standing was, had HOME suffered that requisite personal stake, or had they alleged that requisite personal stake in the outcome of the controversy sufficient for Article 3 standing? HOME alleged that Havens' racial steering, in violation of the Fair Housing Act, it frustrated the organization's ability to assist equal access to housing through the counseling and referral services, and it forced it to divert significant resources to identify and counteract that defendant's illegal conduct. And the Supreme Court agreed. It held that there was no question that these alleged injuries gave rise to Article 3 standing because they represented this concrete and demonstrable injury to the organization's activities, with the consequent drain on the organization's resources. And that was more than simply a setback to the organization's abstract social interest. So it's kind of a paraphrased quote from the Supreme Court that was repeated in decades following the Havens decision. So post-Havens, the lower courts really fine-tune the organizational standing doctrine. For example, multiple circuits determined that like litigation expenses alone are not enough. Orgs can't create standing just by spending money on the lawsuit itself. Then Ninth Circuit added an additional constraint that organizations must show that they've suffered some other type of injury. For example, if an organization hadn't diverted resources to counteract the problem. So in other words, mere resource diversion isn't sufficient unless it was necessary to prevent or address some other real organizational harm. So let's fast forward 40 years. The court revisits organizational standing in FDA, the Alliance for Hippocratic Medicine. So this is a decision that came out in June of last year that I think gave all of us a little bit of heartburn. So I'll kind of briefly go over the facts because facts are very important for assessing standing. So several pro-life doctors and medical associations sued the FDA, arguing that the FDA's relaxation of certain regulatory requirements for mifepristone medication violated the APA. Those regulatory requirements at issue essentially made it easier for doctors to prescribe and for women to receive the medication by, for example, not requiring an initial in-person visit to the doctors. In support of their standing, the medical associations alleged that the FDA had impaired their ability to provide services and achieve their organizational missions, and that they had expended resources to conduct research on mifepristone, engage in public advocacy and public education, and third, to petition the FDA in opposition to the relaxing of those subject regulations. So the associations allege that these expenditures were at the detriment of other spending priorities, which gave them standing under Havens. And if you haven't read the decision, spoiler alert, the Supreme Court disagreed. So while it didn't overrule Havens, the court appears to have narrowed its application. The court emphasized that an organization that has not suffered a concrete injury caused by the defendant's actions can't spend its way into standing simply by diverting these resources in response to defendant's actions. So in other words, the court rejected that Haven stands for the proposition that an organization has standing to challenge a defendant's action whenever it just diverts resources in response to that challenged action. And perhaps more problematically, the court described Havens as this unusual case that shouldn't be extended beyond its context. So the court described Home, that's the organizational plaintiff in Havens, as not only an issue advocacy organization, but also operating this housing counseling service whose core business activities were directly affected and interfered with by Havens' conduct. So in other words, the provision of this false information about housing availability directly affected and interfered with Home's core business activity, ensuring that equal opportunities to apply for housing in Richmond, Virginia. So by contrast, the FDA's actions in Alliance, this relaxation on requirements to prescribe mifepristone, did not similarly impair the medical association's advocacy business. And the court went on to say, even the sincere legal, moral, and ideological and policy objections are not enough to get into federal court. So I think the conservative takeaway from Alliance is somewhat clear. Organizational standing is still viable, but perhaps only in narrow circumstances. Plaintiffs relying on it in plaintiffs relying on it really have to show, this concrete impairment to their core mission, not just a shift in advocacy strategy or policy work. So perhaps a warning to future plaintiffs: rely on organizational standing only if you must, and proceed at your own risk. And that's kind of my overview. I don't, Danny, if you have any
Sure.
questions.
Sure, yes.
Yeah.
Like I like that the sort of like the warning, the ominous warning at the end. I appreciate that. And I have some questions that sort of just jump right off of that. And I'm certainly for you, Zainab, but if Delcy or Mary have thoughts, uh, please feel free to add them. So specific to animal groups, given the Supreme Court's reasoning in this Alliance for Hippocratic Medicine case, is there a path forward for using organizational injury if you're an animal protection organization as a plaintiff? And what would that, if the answer is yes, what do you think that looks like? What's like the highest chance of success?
Yeah, I think in light of Alliance, the most viable path forward is for animal protection groups asserting animal or organizational standing. It really lies with those organizations that provide direct services. So that Alliance decision seemed to differentiate between just advocacy groups and organizations that provide some kind of service. So the kind of easiest example that comes to mind are these animal sanctuaries, right? A true sanctuary's core mission is to provide lifelong care for neglected, abused, or abandoned animals and helping alleviate the kind of captive wildlife crisis that we find ourselves in. Think about the thousands of animals, hundreds of thousands of animals in unaccredited roadside zoos across America. And an alleged injury to that core mission, I think, would go beyond the kind of issue advocacy and aligns more closely with the type of operational activity that the court recognized in Havens and clarified in Alliance. So hypothetically, I think a sanctuary might be able to establish organizational standing if it challenges some unlawful conduct that impairs its ability to offer sanctuary and provide care in a manner that also forces it to expend or divert those resources to counteract that unlawful activity. So very narrow, but potentially viable path, safe path. However, future decisions from lower courts, I think, will hopefully clarify and refine the contours of organizational standing for all of the other organizations that may not want to put their membership out there or don't otherwise want to rely on associational standing for whatever reason to vindicate their own injuries in court.
Have you mentioned lower courts? Have lower courts done that?
Yeah, so I think the short answer is yes, though kind of narrowly. So there's a handful of district court cases out there. Not surprisingly, several of them, if they're able to avoid the organizational standing issue, they'll find standing on another theory and then not have to address organizational standing. But I think the most helpful case out there is a recent case from the Fourth Circuit. As of yesterday, it's the only Court of Appeals decision on organizational standing post-Alliance. So in that case is the RNC Republican National Committee v. North Carolina State Board of Elections. It was from 2024. I think it was also provided in the materials that we provided through the symposium. And yeah, I think that this was like the Fourth Circuit provided a very helpful post-Alliance analysis of organizational standing. So in that case, the plaintiff sued the State Board of Elections over its use of this voter registration form that allegedly failed to require identification information in compliance with this federal Help America Vote Act, or HAVA. They claim that over 250,000 potentially ineligible voters registered using this flawed form, and that the state board's refusal to remove them violated both federal law and corresponding state statutes and constitutional provisions. So although standing wasn't contested by the parties in that case, the court recognized its independent obligation to assure standing exists. And like Delcy warned at the outset, this is a reminder that courts can and will address standing on their own accord because it's a jurisdictional requirement that cannot be waived. So I can't stress this enough. I think especially if you're relying on organizational standing, you better be ready at the outset to provide an abundance of discovery on that concrete harm that your organization suffered, which should be voluminous, and get ready to defend that record on appeal. The court, so going back to the RNC case, the court credited the plaintiff's allegations that because they were unable to ascertain which of those 250,000 allegedly improperly registered voters will be able to vote, they had to divert these significant resources and saw their mission frustrated by the inaction of the state board in remedying the alleged defects in the voter rolls. They also claim this undermined their ability to carry out their core functions like voter outreach, election integrity monitoring, and promoting Republican candidates. So the Fourth Circuit distinguished this injury from the allegations in Alliance, emphasizing that the defendant's actions and inactions directly impact plaintiffs' core organization missions. So promoting election security and providing these counseling services aimed at promoting voter engagement and electing Republican candidates. And that defendants' violation of federal law forced them to divert these resources to combat election fraud, which then frustrated their organizational and voter outreach efforts. So unlike in Alliance, where the plaintiffs responded to the government action with kind of general advocacy, here, the plaintiffs alleged this impairment to their core operational activities tied directly to defendants' unlawful conduct. So, some people might see this as like splitting hairs, angels dancing on the head of a pin, but I think that the Fourth Circuit does seize on something important here. And so kind of going forward, we have to just make sure that if we're relying on Haven standing and, make sure that you're kind of tying that defendant's unlawful conduct to this impact to the core of the organization's mission, and fully fleshing that out instead of kind of providing it lip service.
Great. Thanks. Maybe hopeful, actually, this Fourth Circuit decision. Hopeful going.
Yeah, I think that, post-Alliance, now we're seeing with the few district court decisions out there, we're really seeing that the courts appear willing to find organizational standing where these plaintiffs really plausibly allege that the defendant's conduct directly disrupts their core operations, not just their advocacy or policy goals.
Mm-hmm. Wow. I can't believe it. We're already at time. I think we could go for another couple of hours, probably an hour each on each of these types of injury or theories of standing. But I wanted to thank our panelists, Zeynep, Mary, and Delcy and everyone for joining today and for writing questions. I'm sorry that we couldn't get to all of them, but hopefully we did get to some.